All right, you may proceed at this time.
Good morning. All rise. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no eating, sleeping, talking, no chewing, or arms resting on the bench. Any electronic devices need to be on silent or mute. You may be seated.
All right, thank you. This is case number 2324-0233. This is Christopher O'Neill versus Rival Professional Football League. The matter is before the court, set on for a motion for reconsideration with respect to a bench warrant. The court did grant reconsideration in that regard and set the matter on for hearing on today's date. Do I have any attorney, first of all, any attorney on behalf of either person say something at this time? All right, do I have Mr. Christopher O'Neill?
Yes, good morning, Your Honor.
All right, thank you, Mr. O'Neill. Good morning to you. Rival Professional Football League, do I have an attorney for that organization? Do I have some other person connected to that organization? Say something if you're here.
Yes, you have Mr. Quentin Hines.
All right, thank you, Mr. Hines. All right, this matter is before the court regarding the issuance of a bench warrant, where the court directed that the sum of $2,500, strike at $2,750, representing 50% of the judgment, be paid on or before today's date, and that's where we are with this matter. Mr. Hines, are you prepared to satisfy the $2,750 today, sir?
No, sir. Did you, Judge, receive the motion filed on the case?
No, I have a notation that there has been a motion filed, but I have not received it. But tell me about your motion that's coming after multiple hearings regarding this matter, sir. What is the nature of your motion?
The motion is to set aside the default judgment. Mr. O'Neill, he filed a fraudulent small claims case deceiving the court about money owed, and that was submitted with the motion, the evidence and proof for that. He misrepresented to the courts the parties involved and the defendant's address, and we were never personally served, and we had just went without legal counsel, and it just needs to be known to the court. That's why the motion to set aside the default judgment. He got it. We were never served. We didn't even know about it until after the fact. And after finding the facts of the case, he did deceive the court about monies owed, and then he misrepresented to the court defendants, parties involved, and even their addresses.
All right, the record should reflect on review of the file in this matter. The judgment was entered the 6th of June of 2023. The file shows a proof of service dated April the 11th of 2023. It's 2 years later, and you've been in front of me on at least one occasion before, sir, and this case has been up before the court on multiple occasions. 2 years later, you now bring a motion to set aside the judgment that was entered in this matter by default. Your motion is untimely. You've had multiple occasions prior to this time to raise any issues that you would be raising in the motion to set aside this default judgment. And based upon what I've heard in your allocution or your articulation of the motion is not grounded, and there is no basis for granting the motion to set aside a default judgment in this matter on the facts that you set forth or alleged, nor under the circumstances set forth herein. The motion to set aside the judgment that was entered in 2023, that motion will be denied at this time. We're back to the question of the bench warrant and the setting forth of the funds as I've directed under my order dated February the 18th of 2025. So what say you, sir? You've got to come up with $2,750 on today's date for a bench warrant now issues for your arrest. Coming up with the money, sir.
Well, I'm not in the position to pay the judgment at this time.
Excuse me, sounds like a yes or no question at this time. Are you coming up with the funds, sir?
Is the company coming up with the funds? Because I'm just an employee.
Okay, well, whatever you're gonna do, you're connected to that, so the bench warrant will issue as it relates to yourself. The last time that you were in front of me, you told me that you told me what your involvement was in regards to this company. I don't have a lot of time to go back and forth with that, so I'm gonna go ahead and issue the bench warrant.
No, Your Honor, I just want to say that last time we had court.
I turned you off there because what you're not gonna do is you're not gonna talk over me. I'm directing this hearing. I made some determinations in this matter. You asked me a question, I answered your question. Now, if you have something that you want to file another motion or something about, that's your business. But I'm telling you the direction that this hearing is going. You're not going to take it in another direction. So now, I've made my determination in this matter. I asked you what you wanted to do. And it sounds like you don't want to respond to the court's order, and that's okay. If that's what you want to do, then when the sheriffs contact you, deal with them. All right, I wish both sides well. Good day to you.
Have a good day, Your Honor.
All right, this is case number 06101951. This is Midland Funding LLC versus Lucretia Montgomery. The matter is before the court on the following objections to a writ of garnishment. This matter was before last Wednesday. I adjourned the matter over as there were some discussions regarding whether or not there was an issue, I believe, of identity theft and some other issues associated with this matter. Your appearance for Midland, please.
Good morning, Your Honor. Navjot Francis on behalf of Plaintiff's Attorney of Record.
All right, thank you, Ms. Francis. Good morning to you. Do I have Lucretia Montgomery on this Zoom? Say something if you're here, ma'am.
Hello, Your Honor. I'm here.
All right, good morning to you, Ms. Montgomery. Ms. Francis, thank you, ma'am. And Ms. Francis, update me on this matter at this time. Then excuse me, something went wrong. 1 second. All right, Ms. Francis, update me regarding this matter. I'll come to this.
Your Honor, this judgment is actually against Ms. Anastas Montgomery. We have released the garnishments that were accidentally connected to Ms. Lucretia Montgomery. I did explain that to her. We are going to return any funds we received in the amount of $2,119.77. And then, Judge, we are asking to set aside the judgment as to Ms. Montgomery as well and dismiss the case without prejudice.
So Ms. Montgomery, well, let me ask you, did you think it was worth that week wait? Ms. Montgomery, you still there? You hear me?
Yes, sir.
You think it was worth waiting that week that you didn't want to wait, that I told you needed to wait? You think it was worth waiting that week?
Yes, sir.
All right, real good. All right, real good. So I'm going to release the funds held under the garnishment back to you, ma'am. Moreover, I'm going to set aside the judgment in this matter on the request of the plaintiff in this matter. So that should wipe things out in this regard. I wish you well, Ms. Montgomery. What a difference 7 or 8 days make. All right, all the best to you, ma'am. Thank you, Madam Counsel. Good day.
Thank you, Your Honor.
The court now calls case number 24-165269. This is Midland Management Incorporated versus Roxanne West. The matter is before the court regarding a first hearing The complaint in this matter alleges damages of $1,833.38. Your appearance for Midland, please.
Good morning, Your Honor. Jay Baig, B-A-I-G, P36820, appearing on behalf of Midland.
All right, thank you, Mr. Baig, and good morning to you, sir. I'm looking now for Roxanne West. If you're on the Zoom, please say something at this time, Ms. West. All right, you're having trouble getting, let me see if I can help you out there a little bit. There you go. Can you unmute yourself now, ma'am?
Okay.
All right, good morning to you. You're Roxanne West, is that correct, ma'am?
Yes, I am.
All right, thank you very much. Mr. Baig, update me on where things are regarding this matter, sir.
Your Honor, we did try to discuss settlement. She's not in a position to settle at this time. Also, there may be an opportunity for a hardship consideration. At this time, I'm just requesting your standard scheduling order.
All right, Ms. West, I understand that you took the occasion to at least try to get it resolved. The parties are just not able to get it resolved at this time. So I'm going to move the case to the next stage. That means I'm going to issue a pretrial scheduling order, and you'll get a copy of that in the mail from me. And that order will give the next court date in this matter just beyond 60 days from now. That's going to be on the 22nd of May. When you're going to come back, you will receive that in writing from the court. Over the next 60 days, discovery will be open. That means that if there is any information that is being held by Midland that you think might be helpful to your case, all you need to do is send a letter to them requesting any documents that they may have. They also have the right to send questions to you, requests for documents, requests to admit certain things, and you're required by law to answer those things when they are sent to you, usually within 28 days. That's what will happen over this next 60-day period. And then again, you'll be back in front of me on the 22nd of May at 9:45 a.m. That's a pretrial conference date. All right, I wish both sides well and good day to you.
Thank you.
Thank you. Thank you, Your Honor. I do have one more, Synchrony versus Fulton.
All right, just one moment, Mr. Bay. The court now calls 24-160-783. This is Synchrony Bank versus Sammy Fulton. The matter is before the court set on for a pretrial conference date. The court did issue a scheduling order previously regarding this matter, and then the matter was adjourned from the previous pretrial date. The parties indicated that they were working on a resolution. Counsel, Mr. Vega, I know that you represent Synchrony Bank. You may and let me just look and see if I have Senator Fulton on this Zoom. Mr. Fulton?
Yes, Your Honor.
Right. Good morning to you, Mr. Fulton. I do see you there. Mr. Vega, update me regarding this matter, sir.
Yes, for the record, Jay Baig, P36820, appearing on behalf of plaintiff. According to the records that I've been provided, apparently there were payment arrangements that were being discussed. I didn't have a chance to confirm that with Mr. Fulton because he didn't want to go into a breakout room. So maybe we'll let him speak. If there's nothing that's settled, then I would just want to have time to file and have a dispositive motion heard.
All right, thank you, counsel. Mr. Fulton, I know that there was some discussions about resolving this matter. Have you gotten this matter resolved with someone? What's going on here, sir?
They trying to get $6,000 with the settlement. When I only owe them $1,100 because I paid the balance in full, and they wouldn't take the last payment of $1,100. They claimed they couldn't find the file number, but I had the file number with me.
So it's not settled. All right. So what I'm going to do is I'm going to go ahead and set the matter up for a trial date. And in the interim, any party wishes to file a motion, I'll hear the motion in regard to this matter on the date that I'm setting for trial. So that date is going to be, that date is going to be the 13th of May, 5/13/25. Be a hearing on a motion, but it's also set for trial. If the motion is granted, that of course will resolve the matter. If the motion is denied, then the matter will proceed to trial. The matter set on for 10:30 a.m. on 5/13/25. Right? Wish you well. Okay.
Thank you.
Court now calls case number 24-150256. This is Natasha Ballard versus USA Underwriters. The matter is before the court set on for a pretrial conference date. I know the parties previously stipulated to various items, I believe, that related to discovery. All right, let's see where things are. Your appearance for Ballard.
Mr. Fortner, do you?
All right, your appearance for underwriters, for USA Underwriters.
Yes, good morning. Dylan Beat on behalf of defendant. Mr. Fortner's here. He's still muted. He might have stepped away, but it's a relatively easy conference. We have a facilitation scheduled for next Thursday for this, which would include this matter. So not a lot to really dispute today.
All right, so is there anyone there from Mr. Fortner's office? I know he may be in another court room. Say something if you're there. All right, so what I'm going to do, counsel, is on the representations, and I remember that coming up at a previous hearing regarding there being some global attempt to globally resolve a number of matters. So what I'm going to do is I'm going to send it over so that we might have a more fruitful opportunity to evaluate and assess where things are in this matter. So I'm going to set it for the 17th of April, 4/17 at 10 o'clock.
Okay, thank you, Your Honor. And it should resolve the claims exceed the policy, so we're kind of just apportioning out the policy at this point, it sounds like.
And I remember that coming up at the last hearing as well. Yeah. So we'll take a look at everything. Hopefully it gets resolved. If not, we'll drill down on any issues on the 17th at 10 o'clock.
All right, thank you, Your Honor.
Thank you. Good day to you.
You too.
The court now calls case number 24-172604. This is LVMD Funding LLC versus Leon Hunter. The matter is before the court, set on for a status conference. This is the first hearing regarding this matter. I'm in receipt of defendant's handwritten answer regarding this matter, which raises issues of disability. The court notes that this is a claim for $1,127.17. Your appearance for LVMD Funding, please, sir.
Judge, may it please the court, I'm attorney Richard Rusin, my bar number 35222.
Thank you, Mr. Rusin. Good morning to you, sir. I'm looking for Mr. Hunter, Leon Hunter. If you are on this Zoom, please say something at this time, sir. Looks like I see Mr. Hunter there.
I'm here.
All right. Good morning to you, Mr. Hunter. Mr. Rusin, as an officer of the court, update me on where things are in this matter, sir.
Judge, I can tell you that in this hearing, Mr. Hunter had trouble with his audio before you took the bench, but I can tell you that I've settled this case with Mr. Hunter through his debt consolidation company. Basically, the debt consolidation company agreed that in settlement, Mr. Hunter would pay $850, payable in payments of $50 monthly. In fact, he's paid $250 as of this time. So, Judge, I would gently suggest two things. Number one, that I should send to Mr. Hunter what the courts call a conditional dismissal that will have all those settlement terms that the parties agreed on. I would also ask for scheduling, Judge, that you issue a scheduling order, or you may want to consider adjourning this pretrial for a certain time, so that maybe it might be better. I'll let you be the judge of this. That if we get a date far enough out on your scheduling order, maybe this whole matter can be paid in whole, and I can just file a dismissal. With that, I rest.
So, Mr. Hunter, it seems to me that you got this resolved and you've already began making payments on it. Is that correct, sir?
Yes, I have a financial advisor.
Right. And they worked this out and payments have already.
He
On
works
some
it
of
out and I start making my payments.
All right, real good. So what I'm going to do is I'm going to adjourn it for review. And I think if I review it, it's been around since November, but if I review it in 60 days, I think that'll give us a better gauge of where things are. I don't know that I need to issue a scheduling order. If the parties present an order for conditional dismissal, I'll sign it. Not matter is simply set for review. And that review date is going to be 26th of May, May 26th. It's not a holiday.
26. Yes, it's gonna be 27.
It's got to be the 27th, May 27th at 9:30. So just keep doing what you're doing, Mr. Hunter, and I'll take another look at it on 5/27/25 at 9:30 a.m.
All right. Thank you, Judge.
They deducted out my bank account, so it'll be settled. It will be settled.
Okay.
I don't pay them.
All right. All the best to you.
They deducted out my bank account.
Yeah, I hear you loud and clear. You've already made some progress, so I'm sure it's all going to get taken care of. All the best to you.
Okay, thank you.
All right. Thank you, Judge. Judge Richard Rusin for the plaintiff. I have one more matter unrelated to Mr. Hunter on your docket, and I say that not to usurp your docket, but I have an 11 o'clock hearing with Judge Sabrine. And the case that I'm referring to is a no-show where the file number is 24161-244.
Yeah, it sounds like the one I'm getting ready to call. That's case number 24161-244 as LBNB Funding LLC versus Jesus Coleman Ortega. The matter is before the court, set on for a status conference of first hearing regarding this matter. I have a receipt of a document that the court has treated as an answer. It's a handwritten note from Jesus Ortega. And the court did issue a notice for a hearing on this date. And go ahead and formally enter your appearance, counsel, and then I'll search to see if we have Ortega. Go ahead, sir.
Yes, thank you, Judge. May it please court. I'm attorney Richard Rusin. My bar number is 35222, and I'm the attorney of record for the plaintiff.
Thank you, Mr. Rosen. I'm looking out for Jesus Coleman Ortega. If you are anywhere on this Zoom, please say something at this time. The court, the record should reflect that the court did send out a notice to the address provided. Actually, the address that this matter was started in, that address was on a Rathbone Street in the city of Detroit. The notice was sent out on January 8th. Counsel, I'm noticing that on the answer that was submitted, the answer has an address on Pinehurst. That probably means that that the reason could mean that the reason that defendant is not here is because the address provided would likely be the most current address that Ms. Taylor would have.
Yeah.
So go ahead, sir. Go ahead, Mr. Rusin.
Judge, so therefore, I would recommend that perhaps the court issue an adjourn date, update the register of actions to the address on the answer. Maybe we can get Mr. Ortega to appear, and hopefully we can get the matter resolved.
Makes sense to me. That's what the court had in mind. So I will set it over and with directions that the notice be sent out to the address on Pinehurst Street with correcting things. Now, there is also a phone number provided in the answer as well. So the next action date in this matter is going to be the 10th of April. So 4/10, 14 and 25 at 9:30 a.m.
All right.
We'll send
Thank you, Judge. On that, I rest, and I'm going to Judge Sabri. Thank you.
The court now calls case number 24152647. This is Rodnick Chiropractic versus Citizens Insurance of the Midwest. Matter is before the court, set on for a pretrial conference date. Or your appearance for citizens, please. Do I have citizens? All right. I see Mr. Fortner's office indicating, is there anyone there from Mr. Fortner's office?
I am here, Your Honor. Good morning.
All right, good morning to you, sir. Your appearance regarding Rodnick Chiropractic, sir.
Yes, sir. Michael Fortner, P46541, on behalf of plaintiff.
All right, thank you, counsel. I'm looking for citizens, but I'm getting no response from citizens in this regard. Any information, Mr. Fortner, on this matter?
I don't, Your Honor. Have any information? Would you be willing to put it over a weekend? We'll send them notice.
All right. I'm looking at my notes here. I know that this was something that had to do with a fee schedule, and I adjourned it from the 16th of February. So yeah, let me go ahead and put it over, and we'll renotice it and see if we can get the other side here they usually here. So I'm going to go ahead and set it over for the 9th of April. So 4/9/25 at 9:45 a.m. and we'll send out a notice to all parties in that regard.
All right, thank you, Your Honor.
I thank you. Good day to you, sir.
All right, do I just have one matter or do I have multiple?
You had another one earlier, but the attorney for the other side indicated to the court that there is a facilitation schedule on that matter. And so I simply set it over to give the parties opportunity to go through the facilitation.
All right, and we'll be looking for notice through the mail.
Yes, sir. Yes, sir.
All right, thank you, Your Honor. Always a pleasure. All right.
Yes, sir. All right, the court. All right, the court calls case number 24167805. This is Goach and Sons Towing Incorporated versus Adami Muhammad and USA Logistics and Amazon Logistics. Your appearance for the plaintiff regarding this matter, please.
Good morning, Your Honor. Eric Maxson, P87847, appearing for plaintiff Goach and Sons.
All right, thank you, counsel. Good morning to you. I'm looking for counsel for, I think, Amazon Logistics, please.
Good morning, Your Honor. Anthony Caffrey on behalf of Amazon Logistics.
All right, thank you, counsel. Go ahead and put your P number on, if you will, sir.
P60531.
All right, thank you, counsel. Any other counsels on regarding any other defendants in this matter? All right, so I did see the order extending time for response to pleadings. So where are we regarding this matter? Looks like this is the first hearing in regard to this matter. So somebody update me and tell me where things are, Mr. Matthew. Plaintiff's counsel, go ahead, sir. Update me.
Your
Where
Honor,
are things?
yes, sir. There are 5 defendants in this case. Mr. Caffrey, who's appearing on behalf of Amazon, their office has appeared and filed an answer. Mr. Brazier, who I believe is also present currently, has been served but has not filed an appearance or an answer to date. We've been in contact with counsel for USA Logistics. they have been served. We're still waiting for confirmation from our process server on that. And lastly, the driver in this incident, Mr. Muhammad, has not been served. Your Honor, we've been in contact with Mr. Caffrey's office, and we have agreed that we would like this set out 90 days for discovery, as we'll need some more time to sort out the other defendants as well.
All right, and I thank you, Counsel, for that update. And I think I called the previous, the first three defendants, and I noticed here that there are 5, as you indicated, PSA appraisal, and then Joseph Brazier. Do I have Mr. Brazier?
Yeah, I'm here. Yeah, I filed an appearance. I mailed one in about a month ago. I see it in the Register of Actions. Or filed an answer, I should say.
All right, well, I guess you want me to, I guess you wanted to treat that as an answer. You filed a one-page documented letter form. Is that correct?
Yep, that's it.
That was in December.
Oh, okay.
Counsel, have you received the letter that we're talking about? So,
no, Your Honor.
all right. So you need. I hope you have a copy of that, because you need to serve a copy of that on the plaintiff in this matter. It's not just enough to send it to the court.
Oh, okay.
Did you keep a copy?
Yeah, it's in my hard drive. I can print one out and email it over.
Yeah, you need to do that right. You need to do that right away, so that you know, we can figure out what the next steps are. You might, all things considered, you might want to. Your answer may or may not be sufficient. Is what I'm saying. When they look at it, they'll make some decision as to whether or not they want to attack that answer.
Okay.
So that's why it's important for the comments. Okay. All right. So I am going to go ahead and set up the matter on a scheduling order, and I usually only give 60 days. In this case, I think 90 days might be important, because there are other parties that have not been served or that are just getting served, and so you know that factor will have some bearing regarding this matter. And before I go ahead and set dates, anything, Mr. Caffrey at this time, sir?
Your Honor, I would only ask that Mr. Brazier please provide me a copy of his filing as well.
Yep.
Okay.
And any future filings.
Yeah, yep, that becomes important. All right.
All right. I'll look up your email address online.
Thank you.
So what I'm going to do is I'm going to set the matter over into to June, as that will put us out for 90 days. And so your return date regarding this matter, just one moment here. Your return date regarding this matter is going to be the 23rd of June, 6/23, 25. And that's going to be at 9:30 a.m. You're going to receive in the mail a scheduling order from the court. That scheduling order is going to allow for discovery through that period of time. It's also going to allow some space for filing motions, although it's not setting a motion cutoff. On the paragraph number 6, it will show, it will give you some information in that regard as to how you might get a motion in front of me. Any motions filed automatically be set for hearing on 6/23/25, the date when you return. Unless you need something earlier, then you will file a motion and you will request a hearing date other than the 23rd. Otherwise, any motions you want to file, if you have a problem with discovery, so on and so forth, you can set it for hearing on the pretrial conference date, which is 6/23/25, and I will hear your motion on that date. If you have a dispositive motion along the way, and you feel that the case has come to the point where the court could rule or should rule on a dispositive motion, set it for hearing on the 23rd. Again, paragraph number 6 gives you the direction as to how you go about doing that. All right, so you're going to get a scheduling order in the mail. That scheduling order will have the next action date contained in the order. It will have discovery and things like that. So I'll see you on the 23rd of June at 9:30 a.m. Good day to each.
All right, thank you, Your Honor.
Thank you, Your Honor.
Will that only be for Mr. Brazier?
No, that's all of the.
All of them.
Yeah, so you've got plaintiff, Amazon, and Mr. Brazier. Also, USA Logistics. So you'll have a plaintiff plus three. Yep. And I'll generate that. This is case number 24-24-0403. This is Rosalie Mitchell versus Steve Lewis. Matters before the court set on for an adjourned show cause here. Excuse me, do I have Rosalie Mitchell on this Zoom?
Yes, good morning, Your Honor.
All right, good morning, Ms. Mitchell. Do I have Steve Lloyd on this Zoom? Steve Lloyd on this Zoom. All right, and Ms. Mitchell, I believe I gave you some instructions on the last occasion regarding serving the amended show cause. Is that correct, ma'am?
Correct.
All right, tell me what you did, ma'am.
I went and got the show cause certified, and I brought the proof down there to you, what you instructed me to do.
All right, very well, ma'am. All right, so and I allowed you to serve the document by mail. Is that correct, ma'am?
Correct.
All right. It appears that Mr. Lloyd has not appeared for this show cause hearing, despite having received due notice in this regard. Accordingly, the court will now issue a bench warrant regarding this matter, and the court will set bond on the bench warrant at $5,000. So, ma'am, you have to fill out a bench warrant form and submit it to me. And I will sign that. And then once I sign that form, ma'am, we'll take that to the 17th floor of the city county building to the county sheriff's office. So what you got to submit to me is a bench warrant form. You have to fill that out. I will sign it. I've already set the bond amount at $5,000 cash, and then take it to the bailiff's office and let them take it from there. Understand?
Okay. One more question. Where do I go get that information for me? Go sign up for the bench warrant at?
You can access a bench warrant form through the state court administrator's office online, or you can come to the court on the second floor and fill out the form.
Okay.
All right. All right. I wish you well, ma'am. All the best to you.
All right. Thank you. Have a good day.
All right, the court now calls case number 24-24-1474. Victoria Brown versus Freddie Polanco. Doing business as Polanco Investments. Today is the date and time set for status conference. This is the first hearing in this regard. The court also notes a counterclaim regarding this matter. The plaintiff filed a lawsuit pleading for $7,000 in damages. It looks like the matter was removed from the small claim division of this court to the general civil division, and thus is in front of me at this time. Do I have Victoria Brown on this show? Victoria Brown.
Yes.
Say something.
Yes, I'm here.
Thank you, Ms. Brown. Good morning to you, ma'am. All right.
Good morning to you too.
All right. And do I have for defendant, I believe he's represented by counsel, your appearance at this time, sir?
Yes, Jim Dwarman, P40438 for the defendant and counter plaintiff.
All right. Thank you, counsel. Good morning. Good morning to you, sir. All right. Counsel, why don't you, as an officer of the court, go ahead and update me. And basically what I'm looking for is whether the parties have had any opportunity to kind of talk about this and see if they can find a way forward. Go ahead, sir.
We did go into a breakout room, had some settlement discussions. I will say there's the possibility of settlement. We didn't settle it this morning, but I just need to talk to my client, I think, and get back to Mrs. Brown and maybe have a little more back and forth. But there's a possibility of settlement. So if you just want to send out a scheduling order, it might be resolved before the next date.
All right, Ms. Brown, that makes sense to you as well, ma'am? Some settlement discussion, maybe be able to work it out. You think so?
Do you think y'all can work it out? I hope so. I was asking for the to get my security deposit and dismiss everything as far as talking about non-payment of rent so it won't go against me. That's what I was trying to settle for.
All right, I can't get into the settlement discussion. I just wanted to know that there was some discussions that occurred. So it makes sense to me. Hopefully you can get it, the parties can get it resolved. Let me go ahead and set up a schedule, and you guys keep working on it, see if it get worked out. So I'm gonna set the next court date in this matter. Let's see if I can get you back. Can I get them back on May 20th?
Say May 20th?
Yes.
Yes.
All right, so I'm gonna set it for May 20, 2025. You'll get a scheduling order in the mail from me in the next couple of days with some dates on it. The key date is that on May 20th is when you come back to court at 9:30, May 20th, 2025 at 9:30 a.m. All right, and hopefully you all get it settled. If not, we'll work on where the case goes from there.
All right, they'll be by Zoom again, Your Honor.
Yes, yes.
All right, I would hope that we'll have this resolved before then, but you never know.
Never know. Hopefully it works out for both sides. If not, that's what I'm here for. We'll figure a way forward. Good day.
All right, thank you, Your Honor.
Thank you.
So I have these two of you that I'm going to schedule.
Yeah. The third one is the one with the one you just did. So you got Gooch, you got 805, and then you also have the 69.
Which one?
269. And now you got the 7 court.
Got it. That's what I was looking at, 260.